Good afternoon. Happy Friday. My name is Jim Ludwig. I'm a major gifts officer here at Vegas PBS, and I want to welcome you to our seminar today on real estate in retirement. We hope you enjoy today's seminar. Just got a couple of brief items before we get started. Today's format is going to be a little bit different than what we've done in the past. We hope you enjoy it. Please provide your feedback for us at the end. But before we get started, we are very grateful to have a sponsor for all of our seminars, and that is Silver State Schools Credit Union. So please enjoy this message from Silver State Schools Credit Union.
I'm Scott Arkels, President and CEO at Silver State Schools Credit Union. For the past 70 years, we have been committed to strengthening our community and providing excellent member service and financial solutions for every stage of life. At Silver State Schools Credit Union, our valued members are at the heart of everything that we do. Our purpose statement drives us, prioritizing people over profit. That is why we strive to be a good neighbor by investing time, money, and effort into partnerships that support our community. We are a proud supporter of Vegas PBS. Together, we are paving the path for financial success in our Southern Nevada community.
Thank you so much, Silver Schools Credit Union. We can't thank you enough for being a corporate partner with us. Before we get started, though, I want to ask you for your help. In order for this seminar to be a success, we need your feedback. And if you look to the right side of your screen, you're going to see several options. One, you will see a handout option, which has two attachments that we have. And below that, we have what we call a chat box. I've already put a message into it, which says, we will start in 2 minutes. Thank you for attending today. What I would like for you to do is answer a simple question, yes or no, in the chat box, and then remember to hit send, which is all the way to the right from the chat box. And the question is, were you born in the state of Nevada? Yes or no? I just want to make sure that everybody here can respond. Okay, already got one no. I'm going to wait till we get a couple more just so that we know that you know how to ask our experts a question. Okay, there's two. I'm going to wait till we get at least 5. 3. 4, 5. Okay, so that is how you are going to communicate with us so that we can communicate to the experts and they can help you with any questions that you might have. Now, before we get started, it gives me great honor and pleasure to introduce you to our new president and general manager of Vegas PBS, Mary Mazur, and she's going to give you an update on the status of the station, and I am going to get off the screen so she has all of it.
Well, hello, everyone, and welcome to today's virtual event, our 9th, I believe, in our planned giving seminars, Real Estate in Retirement. I'm Mary Mazur, the President and General Manager of Vegas PBS, and this is the 3rd seminar that I've been able to attend. Now, of course, under normal circumstances, we would be trying to meet together and get together in person, but I'm very optimistic that brighter days are ahead and we'll be able to get together very soon. I want to take this time today to give you a little sense of who I am and my excitement for leading Vegas PBS into the future. I'm very proud to report that the future is bright at Vegas PBS. In 2020, the station was named Nonprofit of the Year by Vegas Inc. magazine, in part due to the quick response and wide range of resources made available to the community from the beginning of the COVID-19 health crisis. For the 12th consecutive year, Vegas PBS ranks in the top 5 of most watched PBS stations in the country. There's more information for you in the Community Impact infographic, which is in your supporting materials. Our station's educational services are in full swing. We recently opened the Special Needs Resource Library for in-person service. The library, which offers more than 14,000 media items, is dedicated to serving those with special needs throughout the state of Nevada, their parents, their caregivers, and their service providers. And this summer, our Ready to Learn team will be able to provide face-to-face workshops in early childhood education to Southern Nevada families in partnership with the Las Vegas Clark County Library District. I want to express my gratitude to all of you for being a part of all that Vegas PBS has achieved. Beyond the programming, we are a connector in the community, a safe place for the exchange of ideas, a vital educational resource, a platform for career training, a critical link in emergency notification system, and so much more. It's through your support that all of this has been made possible, and I personally want to thank you for believing in us and the importance of the work we do. This unprecedented time in our history underscores the global citizenship that we all share and provides a singular opportunity to accelerate partnerships across all platforms. And I'm really excited by the chance to use my experience to expand access to education and to the arts for all of our communities. I'm passionate about the fundamentals of good storytelling and equally passionate about new technology and the capacity to improve the audience experience as well as to improve lives. It's members like you who are the force behind our team, and I believe that supporting our work, you are also truly improving the lives of your neighbors. I want to thank Tom Axtell, our previous GM. Also, Tom was a PBS visionary and created a history of excellence that's nationally known. He built the station from the ground up, and many of you have been part of that journey from the beginning. My plan is to build on Tom's legacy, and one exciting aspect is we have a workforce development department that offers over 350 courses for certification, for professional development, and for lifelong learners. What could be more important in today's economy than to provide an opportunity for individuals to qualify for new careers or advancement in their current professions? I want to thank our Planned Giving Council for their work on these important financial education programs. Today is our 9th virtual seminar, and we are proud to bring you these important financial education tools. I'm looking forward to learning with you about real estate and retirement, and I want to thank the 210 plus members of our Silver Legacy Society, those who have agreed to leave Vegas PBS as a beneficiary in their estate. These testimonial and transformational gifts are vital to the success of our mission. I want to thank Patrick Clifford and Deb Erdman for sharing their expertise on these topics. For this seminar to be a success, as Jim said, we need you to participate. So remember to send your questions via the chat box on the right of your screen. Thank you and enjoy today's program.
Thank you so much, Mary. One of the things that Mary said is that she loves good storytelling. Do we have a storyteller for you today? That is Patrick Clifford, and you'll hear about him in a couple minutes here. But before we get this ball rolling with Patrick, we have 3 questions that we would like to ask you, which is going to help Patrick Clifford from Clifford Senior Law and Deb Erdman from Peak Trust help you get your answers to your questions taken care of. So our first poll question, Summer, if we could put this up. Have you considered purchasing real estate with your IRA, or have you considered purchasing real estate with your IRA? Just click either yes or no. And what it's going to do is it's going to tally all of our responses and give us a percentage. So I'll give you about 30 seconds for that. Shameless plug. Our new season of Outdoor Nevada is on every Wednesday night at 7:30. I encourage you to watch it. John Burke is our returning host, and he puts on an excellent show for everybody. So Summer, let's see if we got our responses. 92% of you, wow, okay, have considered not purchasing real estate with your IRA. Okay, that's a great touch point for our experts here. Question number 2. Do you currently have a mortgage? My answer is yes. But we're interested to see what everybody here responds. And that would be for either your first or second home. Again, this month, coming up in May, we are doing a Downton Abbey marathon all day on Sundays. So look out for that. And our response is 50-50, right on. Okay, so 50% of you have a mortgage and 50% of you do not have a mortgage. Very interesting there. And our last question, and this is probably the most important question you're going to answer for us. How do you hold the title to your home? Is it as an individual? Is it as joint tenants? Is it as community property? Is it in a trust? Are you like me? I have no idea. At least I didn't before I did the prep for this with Patrick and Deb. Let's see if we can get our response. So 42% of you as an individual, 17% as joint tenants. Looks like 8% as community property, 25%, a fourth of you in a trust. Well, we have some great information from you from Deb Erdman about that. And 8%, just like me, did not know. So now what I am going to do is we're going to call Patrick Clifford up. And Patrick Clifford is going to give you a presentation. And I'm going to get off the screen and let Patrick have.
And apparently Jim has muted his microphone as well. So I just want to say thank you to Jim and to Deb and to everyone for allowing me to be here. I'm very excited about this new format because instead of just answering questions, they're going to let me talk, which I love to educate people about the law. And this is one of my favorite topics. Because when I am preparing a trust for someone or doing planning, I like to think that what I'm doing really is I am practicing preventative law, and in just the way that a doctor will practice preventative medicine to make sure you don't have future medical problems and keep you out of the hospital, I want you to avoid future legal problems and stay out of court. And one court proceeding that we all want to avoid is probate. There's lots of reasons why you want to avoid that. Deb's going to be talking about that a little bit later on. But one big reason is it tends to be very expensive. And in the state of Nevada, there is actually a statute that has a suggested attorney's fees for probate. And they start at 4% of the first $100,000, 3% of the next $100,000 in the estate, and 2% of the next $800,000, and it goes up from there if you have an estate that's worth more than $1 million. So if you have a home worth $200,000 that is going through probate, you could expect that your family is going to be paying $7,000 in attorney fees alone. And real property will often trigger a probate regardless of its value. And if you have real property in other states, you might be going through probate in different states. So I hope, like I said, that what I say today you find educational, and I also really hope that it saves you some money down the road. You know, because I see a lot of probate cases that could have been avoided with proper planning and education, because how you hold title to your real estate matters. And this is especially true if you are married. So I want to talk about different ways that real property can be held and some of the differences and the legal implications of each of those. So I'm going to start with a little caveat here, and that is that marital property may be subject to any valid prenuptial agreement you have. So if you do have a prenup and want to know how this is going to affect it, please go talk to a family law attorney. Now, when you buy a house, realtors cannot give legal advice, at least they're not supposed to. Some do, I understand. And the buyer is the one who gets to determine how they're going to take title to their property. But as you can see, a lot of people just don't know, or tell me they don't get asked. So a lot of you are holding title individually, some as joint tenants. 25% in a trust, I'm glad to see that. And 8% of you don't know, but that's really okay if you don't know, because there's an easy way to find out if you live here in Clark County. Because the most recent deed recorded on your property is available online and can be reviewed at the Clark County Assessor's website if it was recorded after September of 1999. If you just Google Clark County Assessor property search, you'll find it. And if your deed is older than that, you can pull it up on the recorder's website. You can't find it, but you can order it. If you have a credit card and $2, they'll email it to you. So let's go over the different ways that you can own property in the state of Nevada. And the first one is individually, and this is the default. If you are unmarried and you're the sole owner of the property, the deed's just going to say, and by the way, if you want to know how you hold property, you look at your deed. It'll say it's from seller to this individual as an unmarried person as their sole and separate property. So it's pretty straightforward. Now, if that person doesn't do something with the property after that, like put it in a trust, then that property is going to go through probate when that person passes away. And as we said, we don't want to go through probate. Now, if there are multiple owners, the default is something called tenancy in common. And each of the owners can have a different share of the property. It doesn't have to be equals. One can own 25, one can own 50, 15 and 10 for the rest. And you can take the property at different times, and every owner can sell or give away or leave their property through a will to whoever they want to without affecting the share of the property that belongs to the other owners. And that's because there is no right of survivorship. Now, right of survivorship is a little concept that means that the surviving property owners will get to keep the property after one of the property owners passes away. So there's another way of for multiple people to own property that does have a right of survivorship, and that is called joint tenancy. So a lot of people, all they know about it is that right of survivorship, and they really do need to know more. Now, you may think it's going to keep you out of probate, but really joint tenancy delays probate. It doesn't really avoid it, because eventually you're going to be down to one joint tenant who's going to have the sole property. And what happens when they pass away? Or what happens if all the joint tenants or both of them pass away at the same time? You're going to go through probate. But there's more to joint tenancy than just the right of survivorship. Take you back to a little bit of a law school lecture. To have a valid joint tenancy, you need to have what are called the 4 unities, and that's time, title, interest, and possession. And what that means is that the owners have to take title at the same time, on the same deed. They have to have an equal interest. You can't have a joint property with one joint tenant owning 2/3, one owning 1/3. And they have the same right to possess all of the property. And if you don't have one of those unities, you don't have a joint tenancy, and it turns into a tenancy in common. And that creates a lot of traps for the unwary, because it's very easy to inadvertently or intentionally convert a joint tenancy to a tenancy in common, and then you lose that right of survivorship. And that can mess up some of your planning. So I'm going to give you an example of that from my own experience. I had a client come in who her husband had just passed away, and they held title to the property as joint tenants. Okay, well, the problem is that at some point they decided they wanted to put solar panels on the roof, but they didn't have very good credit. So what they did is they wrote a deed, 10% of the property to husband's brother, so that he could get the financing they needed for that. And then he quitclaimed it back to them. The problem is, when he had that 10% and they each had 45, you didn't have that unity of interest, and the joint tenancy was destroyed. They could have fixed that if the deed back wasn't just a quitclaim back, but said, from husband, wife, and brother-in-law to husband and wife as joint tenants, but that didn't happen. So no joint tenancy, no right of survivorship, and we ended up in probate. Now, another thing to consider about joint tenancy, like I said, is that equal right to possession. So people think, hey, great, I'm passing this along to my brother when I pass. I've given him the right of survivorship, but you've given him other rights as well. So let's just say your brother's wife kicks him out, and he comes knocking on his door and says he's moving in. Well, you don't want to move in, but you gave him that right to possession of your house. It's probably not what you had in mind. And another problem is that because the property is considered owned 100% by all of the joint tenants, it is subject to creditor claims of any of the joint tenants. So, when your brother's ex-wife puts a lien on your house for that unpaid alimony, well, you probably didn't intend that either. And well, it's not your fault that your brother was a lousy husband, but lesson you want to take away from this is that you can't choose your family, but you can choose how you take title. So choose wisely and make sure it's an informed decision. Now, here is a big trap with joint tenancy, particularly for married couples. And that is, if married couples take title as joint tenants, they can lose that half of their capital gains step up. And capital gains, for those of you who are unfamiliar with the concept, is just the difference between what your property was worth when you bought it, which is called the basis, and what it's worth when it gets sold. And those capital gains get taxed. Now, under the current law, spouses will generally get a stepped up basis. So rather than the value of the property when it was purchased, they will say, we're going to give you the value of the property when your spouse passed away. And that generally saves people a lot of money. Now, mind you, that is the current law. As you may have heard, there are a lot of proposals out there to change the tax laws and do away with this stepped up basis. I don't know what the law is going to be. My crystal ball is a little unclear, but I can tell you what the law is now and how that might affect you. So let me just give you an example. Let's just say we have Bob and Mary Smith, and they used to live in California. When they were married, they bought a little fixer-upper for $200,000 in Palo Alto in 1980. They lived there for 20 years, they raised their family, and then in 2000, they retired and moved to Nevada. But they kept that Palo Alto home and rented it out because, hey, it's a nice source of income in retirement. In the meantime, a little company called Facebook comes along and opens up its headquarters in Palo Alto, and the property values skyrocket. So this house that they bought for $200,000 is now worth $2.2 million in 2020 when Bob passes away. Now, Mary didn't want to be a landlord anymore, so she sold the home for $2.2 million about a month later. Okay, so she has got $2 million, nice return on her investment. So if she gets that stepped up basis, this is how it works. Rather than paying capital gains taxes on $2 million, they're going to say your basis is going to be what the property is worth when Bob passed away. So in her case, she has zero capital gains and she's not paying any taxes on those. But if they own the property as joint tenants, Mary only gets 50% of that stepped up basis. So instead of a $2 million basis step up, she only gets $1 million, and she's paying taxes then on $1 million in capital gains. So the capital gains tax, there's a federal capital gains tax, which is between 5 and 20%. And in this case, it's California because the property's there. California treats capital gains just like regular income. And the rate there in California, if you're making $1 million or more, is 13.3%. So Mary could be facing a 6-figure tax bill that could have been avoided by putting the house in a trust or doing some other type of preventative law. So if you're a retiree from California and still own property there, take the time to look at how you hold title, because you have better things to do with that money in retirement than pay taxes, like supporting Vegas PBS. Okay, I want to talk a little bit about community property and community property with right of survivorship. There is a difference, and it's important to know. Now, Nevada is a community property state, and what that means is when you're married, any property that is acquired from the earnings of the spouses while you're married belongs to a single community and not to the separate spouses. Now, there are exceptions, of course. If you inherit the property, that's your separate property. If it was separate property and you came in, it retains that character. But what happens, it's important to know what happens when the marriage ends, either by divorce or by the death of one of the spouses. And let's look what happens when one of the spouses dies. Well, the surviving spouse keeps their 50% share of the community property, but what happens to the deceased spouse's share? Now, what happens if they don't have a will is it automatically goes to the surviving spouse. Well, they're entitled to it. It's not so automatic because it still has to go through probate. And I have done a case not too long ago where we had to probate the estate of someone who passed away 15 years earlier. And the reason we had to do that is it was community property. And when the surviving spouse went to refinance the house, they said, I'm sorry, you don't have clear title because we never did figure out what should have happened to your husband's share. So we had to file the probate and go through all this again. And if the deceased spouse has a will, well, that community property will pass through the will. So if the surviving spouse thinks, hey, I'm going to get the house automatically because it's community property, not necessarily. She might end up sharing it with her stepkids instead. But you can have community property with right of survivorship. If you have that, and if that's what your deed says, then the surviving spouse is automatically going to take title to the entire property. Now, there's two ways if you don't have it to create it. One is with a deed that says from husband and wife as community property to husband and wife as community property with right of survivorship, or you can do it by recording a homestead declaration in the name of both spouses, and that automatically creates that right of survivorship. And I want to talk to you a little bit about homestead declarations and homestead protections because it's very, very valuable information. Now, people don't realize this, but you can be forced to sell your home or other property to settle a debt. Let's just say, for example, someone doesn't pay their American Express bill, and American Express goes to court and gets a judgment for $10,000. How are they going to collect on that? They can go into the court and get an order to have a creditor's sale of your property. They'll sell your property and they'll take that $10,000 and then you get the rest. You think you're going to get full value for your property to creditor's sale? Probably not. Well, to keep your home from being sold at a creditor's sale, you can do that by having a homestead declaration saying, this is my home, I live here, my spouse lives here, and that way it's going to be exempt. It can't be sold to settle those debts. And that's up to $605,000 right now. Now, it doesn't protect against all debts. If you don't pay your property taxes, you can be forced to sell your home. If it's a mechanic's lien, for example, if you don't pay the guy who put the pool in your backyard, they can go after your home as well. And of course, your mortgage lender can go after your home and make you sell it in order to recover that money if you don't pay them as well. Now, the Declaration of Homestead is a simple one-page form that you can pull from the Clark County Recorder's website. Fill it out, record it. It's a $42 filing fee. And look, $42 to protect $605,000 in home equity, that's a really good insurance policy. Now, I'll tell you this, anytime you record a deed, that's a matter of public record. And there are people who go through and look at those deeds and then send out the official looking junk mail telling you that they will do a homestead declaration for you for a mere $200 plus the filing fee. Throw those away. You don't need them. You can do it yourself. I have clients come in and tell me after I've done their planning, I got this, what do? I say ignore it, because when I prepared your trust and I did the deed, I did the homestead declaration for you as well. Don't pay money that you don't have to. Last thing I want to talk to you about is something called a transfer on death deed, which some people like to use to avoid probate. And the way this works is when you take your property, you can execute a deed that says, I own the property, and when I pass away, I want it to go to this named beneficiary, kind of like a life insurance policy. Now, the pros again are you avoid probate, but there are certain cons as well, because the beneficiary doesn't really have any rights to that property as long as the original owner is still alive. So the owner can sell the property and the beneficiary will get nothing, or the owner can simply revoke that transfer on death deed and the beneficiary gets nothing. So if someone owes you $100,000 and they say, hey, look, how about I just do a transfer on death deed for you instead? Don't take that deal. It's not going to work out. Other problem is that the beneficiary, when they get the property, is going to be subject to any encumbrances and liens like the unpaid mortgage or the mechanic's lien from the pool guy who the owner never paid. And it's also subject to claims, creditor claims against the deceased person's estate. So if you think you're getting that property free and clear, you're not. Because if the person died owing money, they can come after you as the owner of that property, and that property is subject to those claims. So you may think you're inheriting a $200,000 house, but if there's $50,000 in debt out there, that's coming out of your share. So it gets a little more complicated than it needs to be, and there's simpler ways to do it like we're going to be talking about. And as a result of this, it takes a lot longer to clear title. So what's the best way to own property? I would say for most people, that is in a trust. And of course, in order to do that, first you have to have a trust. And then it's just a simple matter of executing a deed to fund the trust. You don't want an empty trust. And the deed's just going to say, from Bob and Mary Smith as husband and wife, joint tenants, to Bob and Mary Smith as trustees of our trust. And that's all there is to it. That way you can avoid probate, and there's a lot more flexibility in what you can do with your property after you've passed. And to talk a little bit more about property and trust, I'm going to hand it off to Deb right now, and we're going to be available to answer any other questions you might have. So take it away, Deb.
Thank you, Patrick. Appreciate that. So folks, this is Deb Erdman, and in a moment, Summer is going to pull up a slide deck. So again, folks, and thank you, Patrick, so much for all that information. And I think it segues perfectly into kind of what I'm going to be chatting with you folks about today. So I'm going to talk about what are the pros and cons of putting that real estate in trust. Next slide, please. Thank you. So I think first it's prudent to just kind of talk about the two types of trusts that are available. You have your revocable trust, which I know, which is where the grantor or the trust maker is, you're the trustee. You control everything that's in there. It's basically kind of a see-through type entity. What's in there really belongs to whoever put the trust together. And on an irrevocable trust, that would be the trust creator or the grantor would name someone else to oversee those assets. And once those assets go into irrevocable trust, the trustee then technically doesn't have control over those assets that are in the trust, the trustee does. So for the 24% of you that said you hold title to your real estate in trust, I'm almost positive most of you are going to have them in a revocable trust. So on the 76% of you that don't have your real estate in trust, I'm hoping you find some good information on the next few slides. Next. So let's talk about what are the pros of putting real estate in trust. And I think Patrick said it very nicely that the biggest one is allowing you to avoid probate. And just really quick, if you're not sure what probate is, it's really you have to go to court and they do like this official blessing, so to speak, and proving the will and saying, yep, this belongs to this person. And yep, this is where that property is going to go. And they will dictate that. And it can be very expensive, like Patrick said. I mean, $7,000 if you have a $250,000 estate, that's a big chunk, and that's just for the attorney fee. There's no, you haven't even brought in the court costs yet, and it's also time consuming. I mean, I looked it up in Nevada, where the minimum probate is 120 to 180 days. That's a long time for something to be held, for an asset to be held up in court, especially property. And I think one of the things that when I talk to clients about this is the fact that when you go through probate process, all your information is public. I mean, the size of your estate, what you own, any debts, who it goes to, when they get it, everything. People can look it up and they can see everything about that particular asset and anything that's gone through the probate process. And lastly, and I think Patrick also pointed to this, if you own property in multiple states and you don't have the property in trust, you will actually have to probate in all those different states. So just think about those costs, everything I just talked about, the expense, the time, it's public. Now you just doubled it because you have to go to the other states. Next. And another big pro of putting real estate in trust is for incapacitation. If the grantor or trust maker becomes incapacitated and the property, the real estate already belongs in trust, then the trustee that you've set up to step in your shoes can just start acting, paying those bills, taking care of the property, making sure the insurance is taken care of. And it's a huge relief. And I can tell you a personal story that I'm going through right now with our own family. My father-in-law was recently diagnosed with Alzheimer's. Luckily, his primary residence was in trust. So when we had to put him into a care facility for the family trying to deal with all the things that go along with that, we didn't have to worry about the home and making sure that we kept it in, it was taken care of, all the bills were paid because it was already in trust. And then the successor trustee was able to just step up. Next. So, with everything, there's a cons. Not everything is perfect. So one of the cons is potential loss of control, because like I said, and this really comes more into play for an irrevocable trust, which I'm sure most of you don't have. But in an irrevocable trust, once that real estate goes into property, the trust truly does own that property. And just that's something to keep in mind. You know, there is a bit of a cost. I mean, it's going to cost you money to put that trust document together, but after hearing the figures of what it costs to go to probate, I think the cost of doing a trust document is not going to, it's going to look minor compared to that. And again, there's the time and energy. I mean, it does take some effort to properly transfer the trust, or properly transfer the real estate into trust. There is certain paperwork you have to do. You know, and it does take effort. So, and as Patrick said, it's not a real difficult process. And next slide, please. I just wanted to show you really quick how, to reiterate what Patrick said, it is pretty simple to fund your trust with that real estate. So the first thing is, step one, contact Patrick or contact a real estate professional and say, hey, I've set up a trust and now I'd like to take my real estate, my home, my primary residence, and I'd like to put it in my trust. I want to retitle it. Step two, they're going to get all the documents together. They're going to give you back those documents and you're going to have to sign them. And you're going to have to make sure that everything is taken care of. Now, the third step, I've only seen this once and it's not been a big deal, is you may, in certain circumstances, have to get permission from an HOA. And it was kind of an unusual circumstance, but I just wanted to point that out. Next slide. Fourth step, again, this does not happen in every case. I have seen it happen, and it's typically for if the property is like a rental type property and it's subject to a mortgage, you have to sometimes get approval from the lender in order to change that. But again, I've only seen that a couple times and it may not apply to you. And then really the last step is recording the deed, is you actually have to take the document, take it to the recorder's office. They're going to put their little stamp on it and they're going to say, yep, this is now how the property is deeded. You can go on to the Clark County assessor and now you can see that your property is now owned by the trust. So for you folks, it's really steps 1, 2, and 5. So that's really all there is to it. So next slide is where I now get to turn it right back over to you, Jim, and we get to, well, before I do that, I just want to thank you. I really appreciate the opportunity to speak to you all today, and I hope you found this information useful, and there's some tools or tricks you were able to pick out of it. So now I'm going to turn it back over to you, Jim, and thank you.
Thank you so much, Deb. And if I could have Deb and Patrick both come back. We have some questions from the audience. And we're going to look like a mini Brady Bunch group here. Okay. First question I have is, and Patrick, it's probably for you, and I'm trying to understand exactly what they're saying. I might need them to type a little, give me a little more specifics. It was during your presentation, Patrick, and it says, how can you avoid that scenario with single owner of property? Does that help?
Yeah, well, if you are an individual and you want to avoid probate, put it in a trust. That's the easiest thing to do. An individual can avoid probate, and it can be like Deb was saying, it's just a simple revocable trust. The property owner can be the trustee and can be the primary beneficiary. And then, you know, when it's a will substitute, you name the secondary beneficiaries, they get it when you pass. In the meantime, you treat it just like it's your own property.
Okay, great. Here's a question that we had prior to this, and I did prep you guys on this one, because every time you're watching TV, there's even some celebrities out there that are endorsing this concept, and we want to make sure that people really know what they're getting into and know the pros and cons of this. And what exactly is a reverse mortgage, and what are the pros and the cons of it?
Okay, so reverse mortgage is essentially it's not that different from a regular mortgage or a home equity line of credit. Only the difference is that you can only get it when you're over the age of 65. And what it does is essentially, rather than you having to pay it back, you get the money. You don't have to pay it back until you're gone. Your estate pays it back. You can, of course, take care of it. And it has certain advantages. It's a good way to supplement income in retirement. It is not considered income, however, so it's not taxed as income. It's not considered income, for example, if you are on Medicaid and you need this money, it's not counted against those resources. It does have downsides as well. One is that you have to continue living in the property. If you are not living in the property a year later, you're no longer eligible. You either pay it back or you could lose the property. The other thing is, it's if the property value goes down, well, then you may be upside down at the end and your heirs aren't going to get anything out of the property. If the property goes up when you pass away, then it becomes a question of your heirs have the opportunity of paying off the mortgage and taking the whole thing, or they will take it subject to a new mortgage, or maybe it just gets sold and the reverse mortgage company gets their share and the heirs get the rest. One other thing I want to mention is that some people use this as a bridge to their retirement. Before they take Social Security, they don't want to take Social Security early because you'd end up not getting as much, but they're no longer working. So what they will do is they will take out that reverse mortgage, and that essentially is what they will live on until they get to the point where they're taking Social Security again.
Okay, excellent. Here's another one that we discussed. I'm going to paraphrase this question a little bit. But Patrick, in your opinion, should you purchase land with your IRA? Just flat out land?
Well, under the right circumstances, it can work. I have yet to, in real life, see anyone with those proper circumstances. I will say this, it's complicated to hold property in an IRA, and it works if you are young enough to take advantage of the appreciation of the property, and if the property is earning you income, generating income in the meantime. So, if you're 40 years old and you can afford to buy a apartment building with your IRA, that's great, you're set. But in my experience, what we tend to see is people buy these undeveloped plots of land thinking they're going to develop them and they're going to make a lot of money and sell them off. I have yet to see anyone who's actually developed these properties. They have these plans, but they never take off. And in the meantime, you have a patch of dirt. And on this patch of dirt, you are paying local property taxes. You might be paying property owners association fees. And the value of your IRA is going down, 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 because undeveloped property does not appreciate the way that developed property does. And also, how are you going to pay for that? It's going to be draining your IRA. Can you just write a check to cover it? Well, not really, because the way the IRS views that is an unauthorized contribution to your IRA, which is why you want to have it be an income producing property. So just to kind of sum up, in my opinion, it's probably not a good idea, because more often than not, I just see it draining people's IRAs, and there's much better uses for those retirement funds than buying property and hoping it appreciates. And by the way, anyone out there, if you have any undeveloped property, if you had it more than a year and haven't developed it, probably a good time to get rid of it. If you still have it a year from now and you just bought it, get rid of it. Don't count on the fact that you're going to actually get it done, because more often than not, it doesn't happen, and then it becomes an albatross around everyone else's neck. I've seen situations where a $5,000 piece of property has kept someone from getting $20,000 in government aid, and you don't want things like that happening. So again, this is my opinion. I don't give financial advice. I'm a lawyer, but that's just my experience, and I personally wouldn't do it.
Okay. And Deb, I think you answered this, but I think we need to emphasize it a little bit more. Can you have real estate in your trust?
Can you have real estate in your trust? Absolutely.
Okay.
Whoop.
Yep, you're good.
Yeah. Oh, I'm sorry. Absolutely. Yes. I mean, it doesn't have to be, Jim, it doesn't have to be a primary residence or a secondary residence. I mean, it can be, we have trusts with all different types of real estate in it, whether it's just raw land or a commercial building.
Okay.
Absolutely. Yes.
Okay. Because when I think real estate, and I think some of our viewers do, they're thinking an actual house with land and the white picket fence and all those kind of things. You know,
Yeah,
it can be pretty much anything, correct?
absolutely. And, a good example is, my family. I mean, my dad's a farmer
Yep.
in northern Iowa, and the majority of his farmland is all in trust. Absolutely.
And if you're
And
lucky enough to own a shopping center,
There you go.
trust too.
If you can title it, you can probably put it in the trust. How's that?
okay. You've already answered this one. Patrick, you mentioned this, but I think you need to go a little bit more into detail for this particular person. Um, what are the hidden dangers of joint tenancy? I know you spoke about it. Thank you so much, because I had no clue what my wife and I have a house, and I had no clue, and I looked at it like you did, and we are now joint tenants. So
Okay.
what are the hidden dangers that she and I currently have with our little home?
Well, they're not hidden anymore because I've just told you about them. The big one, like I said, is that the stepped up basis for your capital gains. And by the way, if you're wondering how that's going to affect you individually, you can go online and find any number of capital gains tax calculators, usually by people who want to sell you something, but the calculator's free. But really the big deal, I'm really kind of summing up here. There's the capital gains. There's the fact that you're giving someone the right to possess your property. You are opening yourself up to paying the debts of your fellow joint tenants. And also, it's a very, very fragile way to hold property. You may think you're getting that right of survivorship, but it's so easy to inadvertently, or like I said, intentionally convert it. And I'll give you an example of that. Let's just say, okay, you and your brother own property, joint tenants, right of survivorship. You may think you're getting a really good deal here because your brother is not doing well and you think he's going to be passing away soon. Okay, so you're going to be inheriting that property. Well, let's just say that your nephew has power of attorney. He says, you know what? I don't want Jim to get that property. I'm going to transfer dad's share to our sister. So he does that, and 50% now belongs to the sister. You now have 50% of that property as a tenant in common, and you don't have a right of survivorship. Now, if you paid your brother big money hoping you're going to get that whole property, well, sorry, you're out of luck. It's very easy to destroy that right of survivorship intentionally or unintentionally. And if you're counting on getting that property when someone else passes, you need to be a little more careful than that. And again, people do this, because they want to leave property to someone else. Again, there are better ways to do it. If your brother wants you to get the property, create a trust. Name you as the beneficiary. It's so much easier. You don't have these pitfalls that you have with joint tenancy.
Okay. And I would be neglect to not answer this question, but can you leave your home directly to a charity such as Southern Nevada Public Television or Vegas PBS? Deb?
Of course you can. Go ahead, Deb.
Absolutely. Just make sure you title it right. That it's not Vegas PBS, it's Southern Nevada Public Television. Put it right there in the trust. For us as trustee, we appreciate it when you put the EIN number, so we make sure we get the right one. And I'm sure Jim would be happy to provide that to you. Absolutely.
And you can leave your property pretty much anyone you want to, as long as it is a human being or a legal entity. You can't leave it to your cat. You can leave it to a trust established for the benefit of your cat, but technically not the beneficiary. But yeah, we talked about pet trust last time out. Why not? But and definitely you can leave it to someone like Vegas PBS as well.
Okay. You got a question in? This is an interesting one. Should I put my burial crypt's deeds in trust? Does that make sense to you, Deb?
Now that's a new one. I've had a lot of really unique ones. I've had, part of a racehorse. I mean, I've seen a lot of, that's a new one for me. Again, if you can title it, but I guess I'm not sure if I know the benefit. Patrick, thoughts?
I'm kind of in the same boat. Yes, you can do it. Do you need to do it? Probably not. I'm trying to think of the benefit unless you really want to give the trustee something else to do. Or you don't want to deal with it. That's fine. But, there are in fact burial trusts that you can set up so that, you can pay for your burial. It comes into play a lot of what I do with the Medicaid planning because burial funds are generally exempt. But because they're exempt, you don't really need to do anything with them, like put them in a trust. It can be done. Why you want to do it, I'm not sure.
Okay. I have another question, and it's, 1 second to go back to it. You see a lot of ads out there where, go online and make your own will. Can you do that for a trust too? And what are the pros and cons if you decide to do that? Deb, do you want to go there?
Yeah, you can. I mean, there's a lot of people. I mean, LegalZoom, certainly. I mean, there's even, yeah, it can be done. Some of those, though, just be careful because we've had some of them come to, to Peak Trust and
Right.
say, we want you name you as successor trustee. Can you take a look at this? And so we do a, complimentary review of the trust document. And here's one that I saw for example, the way this one was set up, there's 4 kids. 3 of the 4 kids had children, one of them did not. The way the document was set up was that if one of the 4 kids predeceased the parents, that person's share went right back to the kids. It never would have gone to the grandchildren. And so when we explained that to the grantors, they were shocked. They said, no. If one of my children that has children predeceased, we want that to go to the children. And that is not what the document stated. If you would have looked at it, you really wouldn't know. And that was one of those that was done literally on LegalZoom. So
I'm going to give my usual spiel about how, you don't see ads on TV for Dental Zoom or Rocket Dentist. People don't want to do their own dental work. I don't recommend you do your own legal work either. There is just as great a potential for disaster. And by the way, do you think someone that does their own dental work is more or less likely to need a dentist in the future? It's the same thing. Don't go bargain hunting for things on TV because, as Deb says, you're going to get what they're selling you. It may not be what you need. If you talk to an attorney like myself or David Strauss, we love putting together trusts. It's a lot of fun and we want to get something that works for you. I'm talking to people who, should know better, sophisticated people, real estate developers, went and got the Dave Ramsey Trust off of TV. No one ever told them you actually had to fund the trust. So they had a piece of paper that says, this is what I want to do with my property that's in the trust, but there's no property. Think of a trust like this. It's an envelope. And you write the instructions on the envelope about what you want to have happen to whatever you put in it. If there's nothing in the envelope, it doesn't matter. So, that is one of the big problems. I would, of course, as an attorney, I would say go see an attorney to draft a trust for you, or at least talk about what you're buying, because more often than not, a bargain's not a bargain if you're getting no value in return. So that's what I say. Look at the value, don't look at the price.
I can give it another example. For those of you here on the last seminar, you heard me say this, but I think it's a perfect thing here. We had a leaky faucet at our house in Ohio. And Jim thought, no problem, I'll just get a pipe wrench out. And I went online to see how to fix it. And yeah, that didn't work out so well. So luckily, one of the people on my board at the college I worked with was a plumber, and he came out and took care of it. And it costs 3 times as much, even with my discount, as what it would have been if I would have called him just to come out for the simple $75 visit for what's needed. So the next time we had a plumbing issue, my wife encouraged me to not touch anything. And I immediately called Nielsen Plumbing from Ohio, and he called me and he says, Jim, did you try and touch it? And I said, no, I didn't do anything. I called you first because I'm sick and tired of putting this kid through private school because of my lack of proper knowledge, and I am not an expert in plumbing, and it's actually costing me 10 times more than what if I would have done if just picked up the call and called somebody to come and get it done right the first time. So that's kind of a Jim example, and to this day I'm not allowed to touch a pipe wrench at my house. Okay, we're coming close to the hour. You guys did your presentations. I can't thank you enough. I hope the audience enjoyed this new format. I got a couple of, they liked it, which is really good. I think we'll go forward with this. But what is out there that we might have brought to the table a little bit more that you just want to emphasize and put that final punch on? Final thought, Deb. I can't
Final
hear you.
thought.
There you go.
Oh,
You're good.
okay. Final thought. If you have a trust, make sure it's funded. You'd be surprised how many times we see that. If you don't have a trust and you're on the fence, if you're in that 76% where your property is not titled in the trust, hopefully there's something in here today that really made you maybe think a little bit more about that and reconsider.
Okay. Patrick, your final thought or thoughts?
First of all, I will say, if you don't know how you hold title to your property, find out. It's actually not that hard. And as we said, it's very, very important because it's going to affect a lot of things about your property, including who gets it when you're gone. And one other thing, if you do own it in a trust, or, anytime your life changes, you want to revisit, your legal documents, and particularly a trust. And if it's been a couple of years and you're just not sure, go ahead and have it reviewed as well. Certain things change. The tax laws change, probably going to change again. I see lots of these, 10-year-old marital A and B trusts. So, it's all, this much goes to my surviving spouse, the rest goes to this trust. It's like, well, that doesn't mean anything anymore unless you've got $11 million in the bank that you're passing through the trust. But the laws change and how we draft trust changes as a result. So find out how you own property and take a second look at your documents just to make sure that everything's up to date.
Thank you so much. I can't thank you two enough for your time and your service on our Plan Giving Council. We have another seminar coming up. We're going to show this on the screen right now. There it is. So Patrick's going to be coming back to join us for guardianship and care providing. This is one of the topics that he's very passionate about. There's going to be some great information out there for you. I'm living with this right now, especially on the care providing with my 90-year-old mom. We also have David Strauss and Shannon Evans. For those of you who have not seen David and Shannon doing their show, it is worth the price of admission, even though there is no cost to come to our seminar. So Patrick's going to be joining those two, and it will be on May 27th at noon. We're still going virtual. We're hoping, crossing our fingers, our toes, and everything else that we have, that we can get back to a small group in person in the near future. We can't thank everybody for being here, for all that you do to support us. If you would like to ask a question personally to either Deb, Patrick, or even me, feel free to connect with us, and we will get in touch with you for any questions that you might have that are out there. Again, I can't thank all of you enough. I want to thank Silver Schools Credit Union again for sponsoring these vital financial education seminars that we have. And happy Friday, everybody. Thank you.
Thanks, Jim. Thank you, Patrick.
Goodbye.
Have a great
Thanks,
weekend, everyone.